DNA fingerprinting has come a long way since its first forensic applications. It is now a staple of our popular culture, a consumer good for the genealogically curious, a mousetrap in the ongoing spectacle of gotcha we play with celebrities and with those ordinary folk who wish only to be on television. But its most serious application remains in the resolution of legal questions involving life and death. The United States is the only nation in the Western world that still imposes the death penalty. Between 1976, when the Supreme Court reinstated capital punishment after a 10-year hiatus, and 2001, 749 convicts were put to death. And by the end of that period, there were 3,593 prisoners on death row. It is against this background that we need to examine the work of the Innocence Project and its founders, Barry Scheck and Peter Neufeld, some of the earliest and staunchest critics of DNA fingerprinting, at least as it was first practiced. Since the early days, Scheck, Neufeld, and other defense attorneys have come to realize that the forensic technology they opposed is actually a powerful tool for justice, more capable, in fact, of exculpating the innocent man than of convicting the guilty. Proving innocence merely requires finding a single mismatch between a defendant's DNA fingerprint and that taken from the crime scene. Proving guilt, on the other hand, requires demonstrating statistically that the chances of someone other than the accused having the specified fingerprint are negligible. As of November 2002, the work of lawyers and students in innocence projects, there is now a whole network of them based at law schools throughout the country, has led to the exoneration of 117 wrongfully convicted individuals. In Illinois, 6 of these mistaken convictions had resulted in death sentences, leading Governor George Ryan to take a remarkable and, given popular support for law and order palliatives like capital punishment, politically dangerous step of imposing an indefinite moratorium on executions in the state. In addition, Ryan appointed a special commission to review the handling of capital cases. Published in April 2002, this commission's report listed among its strongest recommendations that provision be made to facilitate DNA testing of all defendants and convicts in the state's criminal justice system. By no means has all DNA testing of those who insist on their innocence led to the overturning of convictions. James Hanratty was convicted of one of the most notorious murders in 20th century Britain. He accosted a young couple, shot the man fatally, and raped the woman, before shooting her 5 times and leaving her for dead. Despite his insistence that he'd been miles away when the crime occurred, Hanratty was found guilty and sentenced to hang. In 1962, he became one of the last criminals to be executed in Britain. Hanratty died proclaiming his innocence, and his family began a posthumous campaign to clear his name. Their efforts became a cause célèbre. They succeeded in compelling the authorities to have DNA extracted from the female victim's semen-stained underwear and from the handkerchief that had masked the assailant's face. Both samples were then compared with DNA fingerprints from Hanratty's brother and mother. To their chagrin, it was determined that the crime scene DNA had indeed come from a member of the Hanratty family. Still unsatisfied, the Hanrattys had their black sheep's body exhumed in 2000 in order to retrieve tissue samples for DNA extraction. That more direct analysis showed it was unequivocally Hanratty's DNA on the underwear and the handkerchief. Finally, grasping for straws, the family argued, following the recently successful Simpson defense, that the sample sources had been handled improperly and become contaminated. But the Lord Chief Justice proved less distractible than the Simpson jury. He rejected this claim out of hand. The DNA evidence establishes beyond doubt that James Hanratty was the murderer. Usually the strongest objection to reopening a case comes from the district attorney, who is understandably reluctant to see a hard-won conviction subject to post-trial scrutiny. But sometimes such rigidity can be self-defeating, and if prosecutors have now learned that genetic evidence can nail a case, they should also recognize that DNA may also be the surest way to keep one shut. The example of Benjamin Lagur illustrates the point. Sentenced in 1984 to 40 years in prison for a rape in Worcester, Massachusetts, he never stopped protesting his innocence. Like Hanratty, he attracted a retinue of rich and famous sympathizers who in 2001 arranged and paid for samples of DNA to be analyzed. The results must have surprised them all. Lagur was the rapist. One can imagine that a man facing 40 years behind bars rightly imagined he had nothing to lose in making such a demand. But ironically, it had taken 2 years to get the district attorney's office to agree to the DNA fingerprinting. As an editorial in the St. Petersburg Times sensibly remarked, in hindsight, the prosecutor could have wasted less time arguing and gotten the pleasure of saying, "I told you so," much sooner had he consented early on to the DNA test. Civil libertarians will always object to the broad application of DNA fingerprinting in society as a whole. But it is hard to argue with the social utility of applying the technology to those who, for whatever reason, pass through the criminal justice system. For the chances are, sadly, that those who pass through once will pass through again. Criminological data indicate that those convicted of minor crimes are likely to commit more serious offenses. 28% of homicides and 12% of sexual assaults in Florida have been linked to individuals previously convicted of burglary. And such patterns of recidivism can be detected among white-collar criminals as well. Of 22 who had been convicted of forgery in Virginia, 10 were linked through DNA fingerprinting to murders or sexual assaults. It would seem prudent to make the corporate bosses of Enron, Imclone, and Adelphia Communications provide DNA samples. Efforts are underway to broaden DNA fingerprint databases. Recently, the British government has proposed allowing the police to keep DNA samples taken both from acquitted defendants and from those arrested but never charged. The same rule would permit the authorities to keep samples given voluntarily, when, for example, the police test everyone in a location, as they did in Narborough. These changes in collection rules will triple the number of entries in the police database within 3 years. In the United States, 19 states now collect DNA samples from all felons, not just those involved in violent crime. I think everyone should give a DNA sample. It is not that I am insensitive to the concerns about individual privacy or to the potential for inappropriate use of genetic information. As I've said earlier, in my role as the first director of the Human Genome Project, I set aside a substantial chunk of our funding to examine such questions in relation to clinically applied genetic information. But criminal justice is a different matter. Here, by my calculation, the potential for the greater social good far outweighs the risks of abuse. And since we must all surrender something for the benefit of living in a free society, the sacrifice of this particular form of anonymity does not seem an unreasonable price to pay, provided our laws see to a strict and judicious control over access to databases. Frankly, the remote possibility that Big Brother will one day be perusing my genetic fingerprint for some nefarious end worries me less than the thought that tomorrow a dangerous criminal may go free, perhaps only to do further evil, or an innocent individual may languish in prison for want of a simple DNA test.